Thank you. My name is Alan Zetterberg. I live at 124 Random Road. My name is Alan Zetterberg, Z like zebra, Etterberg. I live at 124 Random Road within the Carnassa Park area. I do swear to tell the truth, although I'm not sure that I'm giving testimony or what here. I am also the chairperson of the Carnassa Park Housing Board. Mainly, I would like to correct a number of I guess misunderstandings or misstatements that have taken place in the record prepared by your staff and in what's been said tonight. First of all, for your general information, we do not have a homeowners association. There is no homeowners association. There are deed restrictions which apply to 45 properties, and they have so applied for 70 years. And there is a housing board that is created by those deed restrictions, and that housing board, which is duly elected by all 45 property owners, has the responsibility to enforce those deed restrictions. Secondly, and I'm turning now to the staff memorandum concerning this, section 4.1, there's a statement in there that the deed restrictions or some restrictions may or may not be valid. I cannot understand why there would be a statement that they may not be valid. Mr. Solo, when was making his presentation, he also made reference to whether they may be valid or not. I don't know where that comes from, but I assure you the deed restrictions are valid. That would not be disputed by the proponents before you. You can hear that they've gone to great efforts to try to apparently try to comply with them. So we do have them. They are valid. Further, there was a notice letter sent out. I believe it's required. I'm not sure. I've never appeared before the planning board before. I'm not sure of exactly what the requirements are, but there is a notice letter that goes out to neighboring property owners. And I understand that that letter went to other property owners as well nearby. That letter stated that all Carnassa Park requirements have been met, and that is simply not true. So that information going, if it's in your record, I state that it's not true, and I state to those who receive that letter that it is not true. They have not been met. I would also like to direct your attention to the minutes of the June 13th subcommittee meeting, which also states, in connection with what you've just been hearing about, that the proponents here have releases of 30 out of 45 residents. The housing board is in possession of more than 15 statements signed by owners that do not agree with the subdivision and do not support it, so you can do the math. Those don't add up, and we don't believe that the proponents do have. They may have something in their possession, but we don't believe they're valid, and in fact we believe they were probably obtained based on incorrect information made to the people who were signing them. And likely those will eventually get into litigation, and we'll see where we wind up. But the housing board challenges those. Mr. Tar just made the statement here when, in response to a question, that we met with the board. In fact, there was a meeting last fall, a little over a year ago, I believe, at the Squeers home. That meeting was set up specifically for the Squeers and their attorney to present signatures to the board, and they did not present them. This is the first time we've seen that after a whole year on the screen tonight. A further point is that under the deed restrictions, getting 30 signatures or 2/3 of the owners does not allow you to subdivide your property. There is a different procedure for subdivision, and that procedure has not been met by the proponents. Now, lastly, I just want to speak to this issue that's been discussed by several of you, and it relates to this issue of the counsel being provided to you that the planning board should not consider private deed restrictions. I'm not going to dispute what's in this, the real estate law experts here, but I would say that what's happening here is that you're going to have an odd situation where if you approve this, you are going to be approving something that contravenes the law of the state of New Jersey. The law of the state of New Jersey, these deed restrictions are a part of the real estate law of the state of New Jersey. And so if the planning board approves this subdivision, it is in essence approving something that is in violation of the law. What we're hearing is the planning board has to go ahead under its own procedures. I'm not an expert on that. I defer to your counsel. But you wind up with a situation where you're approving something that can be said to be a violation of the law of the state of New Jersey. And the housing board, on behalf of the homeowners who elected them, do intend to initiate litigation when and where appropriate in order to protect the deed restrictions and the no subdivision clause contained therein. I'd be happy to address any questions that any of you would have now or later. Thank you.
Thank you.